Program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Joe Sam Robinson. It's my pleasure to have with us tonight Mr. Buck Melton. Thank you for being with us tonight, Buck.
Glad to be with you.
Now, tonight we're going to, I think, have a pretty interesting conversation about, I know, one of my favorite subjects, and yours as well, the United States Constitution. And you're something of an expert on that subject, are you not?
Well, I have been studying it for my entire adult life and
Yes.
for a few years prior to that as well. So
Yes.
I do find it interesting. 4 pages long, and yet
Yes,
it continues
yes,
to occupy
yes.
us for 200 years.
Now, in your travels, I think you have a PhD and you've been to law school. Maybe you could chat a little bit about some of your background and
That's correct.
accomplishments on the subject.
Absolutely. Graduated Mercer in 1984, and from there found my way to Duke University, where I got my doctorate in constitutional history.
Yes.
And then after a few years of teaching, I followed that up with a law degree from the University of North Carolina at Chapel Hill. And that's interesting because UNC versus Duke is very much like
Yes.
Tech Georgia down here.
Right. So,
Puts me in an
that's
interesting camp.
probably, there were some moments that your loyalty was probably suspect between those two institutions. Is that correct? You had to
I
be
couldn't
cautious.
possibly comment on that.
Okay.
And can't make a record of this.
Well,
from
we don't want
analysts.
to extract any great secrets about your
Indeed.
loyalties tonight, Buck, so we'll be cautious about that. Well, you've written a number of books, and you're a scholar in residence at Versa, so a pretty extraordinary and illustrious background, I must say.
It's been an interesting ride.
Well, now, I think in our show, we often discuss healthcare issues, and I think one of the extraordinary events of actually our generation, in a way, is the Health Reform Act passed in 2010, which basically is going to rejig 1/7 of the United States economy, have an enormous impact on our world as we know it. And that's going before the Supreme Court. It has been before the Supreme Court, and a decision is going to be made soon on that. Is that correct?
That's correct. Briefs were filed some months ago. The oral arguments
Yes.
were held just a few weeks ago, and they were very long oral
Right,
arguments
right.
for this age.
Yes.
And we can expect the decision with a great deal of certainty at the very end of June, possibly the first day or two of July.
And if you might, Buck, I don't know if this is possible, maybe you could summarize for our audience the two arguments that the Supreme Court is weighing: the argument that supports the Obama health care plan and the argument against it.
Yes. Well, the argument for it rests on Congress's power to control or regulate, if we will, interstate commerce, which is found in Article 1 of the Constitution. And the commerce power has been used, especially for the last 60 years, to justify a great deal of national federal regulation of various economic measures. And therefore, obviously, healthcare has a lot to do with money these days.
Yes, yes.
And healthcare is a national system. And so the proponents of what is called Obamacare,
Yes.
sometimes in derision,
Right,
is that since this is interstate commerce, obviously the national government has the authority to regulate it.
Yes.
The opposing view is that this is not so much regulating commerce as creating it by
Yes.
saying that everyone has to buy
Yes,
health
yes.
insurance. And once it's been created, it can therefore be regulated.
Yes.
And that this is simply taking commerce too far, the notion or concept of what commerce is. And if that happens, then there's literally no limit to the power of the federal government by simply invoking the magic phrase interstate commerce.
You know, I enjoyed listening to some of the radio, I guess, transcripts of the debate or the lawyers opining before the Supreme Court. And it seemed to me the justices were interested in what limits, if the Commerce Clause were allowed to be unchecked, they were searching to find a limit to the legislative branch's power. And did you find that be the case? What would be the limit?
Yes, and that's the main concern, because although the federal government has passed laws on just about everything today, that was not the original idea. That because of
Yes.
our own American Revolution, we were leery of a powerful central government. Originally, that government was based in London,
Yes.
and then eventually in New York and Philadelphia
yes.
and Washington. So the whole point of the written Constitution was to give the national government only certain powers, and beyond that, the national government was not supposed to go. But in the course of 200 years, the national government has found ways to expand its power by using the delegated powers that are actually written in the Constitution. And the interstate commerce power is the best example of that. As just one example, in 1964, when the Civil Rights Act of 1964 was passed, the Heart of Atlanta motel case and the Katzenbach case in Alabama said that because persons of color drove and purchased and sold in interstate commerce, that motels and restaurants could no longer discriminate.
Yes.
Even though Congress does not have the power directly to regulate desegregation or discrimination based on race, Congress found a way to do that by using the interstate commerce power.
Yes, so this is quite in a way, the philosophy of our nation, that whether we're the separation of powers, the idea that some powers are reserved for the states and the people, and others, the so-called enumerated powers, reside in the federal government. And this going back and forth over our nation's history, it does appear the Commerce Clause has been used as a wedge to basically expand federal power in all directions. Is that a fair statement?
Yes, it certainly has been, and I don't think it would get any disagreement on that. I think the disagreement is whether or not this should have been the case, or to what degree this should have been the case.
Yes, I'm not, I make the joke, I'm not a lawyer, but I pretend I play one in the doctor's lounge. But, so I'll just pretend I'm one. But, some of the cases that are out there, I've just glanced just upon, it does appear the courts have surprisingly upheld a lot of the arguments that are being presented by the pro-healthcare reform advocates. I mean, they've said, I think there's a marijuana case, they've said, okay,
yes,
and there had been a 1942 case with dairy farmers.
Yes, yes.
The federal government, or the Supreme Court, has said pretty definitively in several cases that if you are more or less locked in a treehouse, the federal government can do what they want to with you. Is that a fair statement, or can you bounce that basketball a little bit?
I think this is actually the issue that's on the table for us right now in these next few months. As a matter of fact, the court has already held its vote. We just won't find out what that vote is for a while. If you look at the history of the Commerce Clause, it was very hotly debated from around the 1880s down to the 1930s. And the decision in each particular case depended largely on which justices were on the bench
Yes.
at that particular moment. Some cases upheld the broad power of Congress under the Commerce Clause to regulate interstate prostitution, for instance, or the interstate sale of lottery tickets. Other times the court would strike down Congress's regulations, such as regulations on the use of child labor in factories.
Yes.
Finally, after a big showdown between President Franklin Roosevelt of the New Deal and the justices in 1937 and 1938, the justice largely backed down, and since then has said that as long as it's economic regulation, Congress can pretty much do as it wishes with interstate commerce. The most extensive interpretation probably came in the 1942 case of Wickard versus Filburn, which is the case that you were referring to, when a farmer was growing corn on his own farm to feed his own cattle and his own family, not to sell it in interstate commerce. And therefore he challenged the various federal regulations limiting quotas on corn production. And the Supreme Court said that even though you're not actually selling this in interstate commerce, the fact that you're growing it means that you don't have to buy it in interstate commerce, and therefore, even though this is an entirely local operation, you're having an effect on interstate commerce, and we can regulate you.
Now, you mentioned the way the court swings back and
Yes.
forth, and I mean, if one can, I think lay people often imagine, rightly or wrongly, that there's some kind of superior wisdom the Supremes possess, and that the decisions that have been made, the wisdom that's been put before them, there's the great set of books, and they very carefully make their decisions based on the precedents that have been put there by past judges. But they seem to swing back and forth pretty decidedly. The year 1942, the country was at war. There was a huge, everyone needed to be in the trenches to resist our enemies. Everybody had to participate, and that, in my opinion, doubtless influenced that decision. But it goes back and forth depending a little bit on the way the wind blows. Is that true or not?
It certainly was the case in the 50 years or so preceding the Wickard case. Ever since the cases of Darby and Wickard, which were in the early 40s, things have changed. And generally speaking, in terms of the commerce power, the courts have deferred to Congress. Now, there have been two big exceptions to that. One in 1995, the Lopez decision, and then one in 2000 with the Violence Against Women Act. And those are both remarkable because those are the only two times since the early 1940s that the Supreme Court has said there is a limit to Congress's power under interstate commerce. It actually did strike down two sections of laws on those occasions.
Do you think the court was frightened? You mentioned Franklin Roosevelt, 1937, 1938. I mean, this is when the Supreme Court was striking down the New Deal and the extraordinary expansion of government power. The idea was that the country was on the ropes, the Depression was there, the feds had to do whatever it took to save the situation. And as I can recollect the story, there was a threat to basically expand the number of justices.
Yes.
There's no limit, or is there a limit to the number of justices on the Supreme Court in the Constitution?
In the Constitution, there is not. The Supreme Court is actually the only federal court that is established directly by the Constitution. Theoretically, Congress could pass a law tomorrow abolishing all other federal courts. It can't do that to the Supreme Court, but it can regulate the number of justices. It's gone from a low of either 6 or 7 to a high of 10. For the last 150 years or so, it's been 9.
But so it would be possible. So just recollecting this sort of clash of the different divisions of government, the branches of government, 1937, 1938, those judges were thoroughly frightened. This was kind of like the Great Reform Bill, 1832 Reform Bill in the UK, when
very much so.
The idea was we're going to change government, and if the House of Lords was blocking this reform bill, and they said that King William said, yes, either you go along or we'll just create hundreds of lords and we'll put it through. And Franklin Roosevelt threatened the court, did he not?
Yes, it was known as the infamous court packing plan. You have to remember that Roosevelt had just won re-election. He was immensely popular, but by a vote of 5 to 4, the court was striking down most of his New Deal legislation. So he said, why don't we just pass a law saying that for every justice over the age of 70, we'll appoint a fresh, new, young judge who could help with the workload, he said. And he took a severe setback in public opinion for even proposing that. But yet it did frighten the judges. Actually, there's an it's a great story, but there is an indication that 2 of the judges, I believe it was Chief Justice Hughes and Justice Roberts, had actually begun their swing towards a pro-New Deal stance before the court packing, just before the court packing plan was announced.
Now, we recently, I think, in fact, I've had occasion to criticize the president on this show about his comments about the ability of the courts to exercise judicial review. He recently sort of went along with with FDR's antagonism toward the Supreme Court by saying maybe the courts don't have the right to pass judgment on acts of Congress. I mean, was that an overstatement, or what do you think is going on? Any comments? FDR and Obama both having trouble with the court?
Well, you have to remember that politicians tend to engage in hyperbole. The old joke about how do you know when a politician is lying is lips are moving. But this one really was quite extreme, and the quotation was more or less that he can't believe that the Supreme Court would take and here I am quoting, the unprecedented, extraordinary step of overturning a law passed by a strong majority of a democratically elected Congress. Well, the fact is the Supreme Court has struck down probably at this point hundreds of federal
Yes.
statutes, so it is not unprecedented, nor is it particularly
Yes,
extraordinary.
yes.
The majority of Congress was not a strong one.
Yes.
It passed by a bare vote of 1 during the
Yes.
reconciliation process. And every Congress we've had has been democratically elected. So
Yes.
I'm afraid there are just so many problems with that quotation that it's not even funny.
Well, since he's not here to defend himself, he won't beat him up too much. But nevertheless, I think he was an enormous error in that statement, very inflammatory, potentially evil statement.
Yes.
So we have to be we have to be very cautious in our republic that each branch doesn't overstep its appropriate role.
Yes.
And that's
His press folks did, I think, the very next day try to walk it back a bit and say that what he meant was that it's extraordinary for the court to strike down economic
Yes.
legislation.
Right.
And that's a more defensible statement.
Yes.
But even so, as I was saying, in both the Morrison
Yes,
case
yes.
in 2000 and the Lopez case in
Yes,
95, the court
yes.
did do that. So.
Now, as you're an expert on the Constitution, I mean, haven't each of the branches of government episodically tried to eat out of the other's bowl? I mean, the
Oh, yes.
judges have tried to do things, the executive tried to do things. I mean, they're constantly, there's a tension between those branches.
Yes, and that's actually how it is designed to be. And this goes back to Montesquieu and the idea of separation of powers that our
Yes.
founders drew very heavily on
Yes.
when they wrote the Constitution. And the idea is that that no one man or group of men,
Yes.
or today group of people, would have all the power. It would be divided up, and they would be jealous of their prerogatives.
Now, just to talk about, this is in some ways the foundation of our republic, and it does sometimes, in a way, it's at war with efficiency. So
Yes.
if you have a unitary system, I mean, you could say, for rightly or wrongly, back in the good old days of the Soviet Union, if the Soviet Union wanted to put a particular power plant here or there, they could efficiently put power plants wherever they
Yes,
wanted to.
yes.
There were no restraints, there were no checks on the power of the government to do things in an efficient fashion.
Yes. It reminds me of an oral argument that took place about 20 years ago before the Supreme Court, and it was about some criminal statute, but someone had been arrested for
Yes,
smoking marijuana
yes,
in his
yes.
car. And I think Chief Justice Rehnquist asked the attorney, wouldn't it be more efficient to search the car without a warrant? And Justice Thurgood Marshall immediately said, well, if you're going to look at it that way, it'd be more efficient just to shoot him right there without a trial.
Yes.
It's not all about efficiency.
So that's exactly right about our healthcare system. If I could say it that way, I mean, one of the ideas is one can propagate different arrangements
Yes.
that really, you could say, were more efficient. But the difficulty that with that arrangement is that it runs straight into notions of liberty and the whole way that we conduct ourselves here. So there's a trade-off that happens, and and I think that's what makes our system work a little bit. We might not be as quite efficient as I don't know the Poles were in 1950 in some ways, but our liberty is a really important part of our life, and we treasure that.
Yes, and this is actually one of the very first lessons I try to teach my students in any constitutional law class, that in light of our Declaration of Independence and our fear of the central government in England, and in light of our disappointment with the Articles of Confederation, our first national constitution, in which the national government had practically no power at all, the great dilemma of American constitutional government was then and continues to be today. How do we grant the central government enough power to govern effectively while at the same time preventing it from becoming tyrannical?
And so, just a layman reading the Constitution, it appears their limitations are just powers reserved for the people in the states. They're just the document is just full of references in that direction. The Bill of Rights, and the amendments that have been put in really often restrict federal power. So that
Yes.
the document is strongly tilted toward preservation of individual liberty and restraint of federal intrusion into that area. Is that
Yes.
a fair statement?
Yes. As a matter of fact, before the Bill of Rights was introduced, because it was not part of the original Constitution, it
Yes,
came a year
yes,
or two later.
yes.
Thomas Jefferson and James Madison had a correspondence as
Yes.
to whether or not a Bill of Rights was even necessary.
Yes.
And Madison originally argued that it wasn't necessary
Yes.
because the national government only could exercise the
Yes.
powers that had been expressly given to it.
Right.
Jefferson talked him out of that, saying it's better to have additional limitations just in case. And I
Right.
think that history has probably borne out that Jefferson was correct there.
Now, you've used a word that I'll throw you a softball on, which is necessary, proper and necessary.
Yes.
Can you opine a little bit on that, Buck, about what role this plays in this debate and that turn of phrase?
Yes. Most of the powers that Congress has, not all of them, but most of them are found in Article 1, Section 8. Congress shall have the power to lay taxes, to regulate interstate commerce, to declare war, to establish post offices, to pay for an army and a navy.
Yes.
And then the very last clause in that section is to make all powers which shall be necessary and proper for carrying into executions the foregoing powers.
Yes, yes.
And the question is, does this allow us to see implied powers that the
Yes.
government has, even though they're not specifically written down?
Right. Now, listening to the debate the Supreme Court had, which was really an extraordinary treat in a way to listen to that,
Yes.
I might say. But there were the justices talked about necessary and proper, and the case might be that the Health Care Reform Act was necessary, but the judges wondered, is it proper? Proper in that it must comport with the language of Constitution and in general the customs of the country.
Yes, and this is an important point to understand, that the necessary and proper clause is not freestanding, that it has to be linked into one of the preceding enumerated listed powers. Once again, necessary and proper for carrying into effect the previously
Yes,
listed powers.
yes.
So is it really a necessary and proper aspect of the commerce power
Yes.
that would allow us to regulate the national health care system?
Now, what about this, Buck? I mean, I've heard this. You know, we have these very arcane arguments in the doctor's lounge on these subjects, but I've heard it said that it could be the police powers that the states have would allow the states to be far more aggressive than the federal government could be.
Yes.
So if the state of Georgia said you can't live in a treehouse or whatever, we decided no tree houses allowed, then they would have a more legal standing to do that than would the federal government.
Absolutely, and this is that the current presumptive nominee Mitt Romney catches a lot of grief for having backed what is called derisively Romneycare.
Yes.
The basic difference of that is one of federalism, that states can do this, whereas the national government, that's a much bigger question. That states have always traditionally been seen to have a thing called the police power, or the power to pass laws to regulate public health, safety, morals, and welfare.
Yes.
The national government has never been presumed to have that kind of power. Instead, it's got to link into one of those express powers, usually in Article 1, Section 8, sometimes in another part of the Constitution.
So in looking at reform of the healthcare system, I mean, the Constitution and the interpretations of the Constitution would allow the states to experiment in different, I guess, as long as it didn't violate, I guess, the protections the laws give our citizens, different kinds of healthcare arrangements that could be more extreme than the federal government could accomplish.
Yes, and that's quite possible. Putting on my pro-Obama cap for a moment, I would say that the big objection to that is that healthcare very much is a national system at this point, and that therefore if you have 50 different states coming up with 50 different attempts to handle this, then you're going to have chaos. I think that would be the government's objection to doing it that way.
Well, if I could hit the tennis ball back to you,
Absolutely.
Buck. One of the things is, as we try and perfect the system, one of the great, I guess, advantages of our federalist system and of our republic is that it gives lots of room for experimentation. I think it's true enough that we have all these systems, and many of them might be thought to be inefficient, and there are all the advantages that occur with a uniform system. But as we try and find things that work, it's not a bad idea to have experiments in different places And often that's the way to accomplish things.
Yes, and actually during the progressive era of a little over 100 years ago, the late 1800s, the very early 1900s, you often saw the states taking the lead, and sometimes they were even referred to as laboratories of democracy, because they would game things out and try things
Yes,
on a relatively
yes,
smaller
yes,
scale,
yes.
and the national government would then sometimes step in and co-opt, if you would, some of the better ideas.
And other states would. I mean,
Yes.
there are many examples of that. Well, now, you were mentioning, we had a little talk before the show, and you were talking about President Obama and his similarity with President Wilson. And that's a rather complicated argument. Maybe you could repeat that. What are some similarities between
Well, yes. The political right, obviously, I think that probably any reasonable person would say that on the political spectrum, President Obama is probably the farthest left president we've ever had, just as I think you could probably say Ronald Reagan was the farthest right. And therefore, the current political right, the Tea Party, for instance, likes to compare Obama to Jimmy Carter, whom they largely hate.
Yes.
I think that the better comparison is to Woodrow Wilson, that Woodrow Wilson was a constitutional scholar. Obama, I would not call a constitutional scholar. He has taught constitutional law at the University of Chicago. Both of them have evinced a dislike for the system of separation of powers that we have, precisely because it does tend to be more inefficient, as we were talking about earlier.
Yes.
I think they would both prefer a parliamentary government. Wilson, in fact, acted more as a prime minister than as a separate president. They both tend to be very internationalist in their outlook. Wilson's great statement, of course, the world must be made safe for democracy. Democracy and the American image, of course,
Yes.
but still an international community. The League of Nations, an international
Yes, yes.
body designed to resolve disputes peacefully. Obama himself, I think, takes a more internationalist view. He doesn't really seem to be interested in the idea of American exceptionalism. The fact that there is not a great deal of enforcement of bans on illegal immigration today. I think there are good arguments to be made that we need migrant workers here. But if that's the case, we should repeal the law making them illegal immigrants.
yes.
But just refusing to
Yes,
enforce
yes.
that law and going after Arizona for trying to do so. So international trade, international
Yes.
political arrangements. He's very much a Wilsonian, and
Yes.
just about a century after Wilson himself
Yes.
was president.
Well, that's a rather good analogy. Now, let me slightly, I've sort of criticized the president slightly, so let me say something in his favor, taking the reverse argument. Really, the system is pretty complicated. We've got all these extraordinary technical problems. We've got all these abuse issues that are just extraordinary. We've got all this problem, money, these difficulties. Tackling this problem is going to be fraught with mistakes, errors, but he's trying to do something about it. It's a big deal. I mean, I think we can give him that point, can we not?
I think so. And one thing that the American people tend to like is somebody who does something.
Yes.
And takes us back to Theodore Roosevelt, who was
Yes.
a very active president
Yes.
and was reelected in
Yes.
his own right by
Yes.
very high
Yes.
figures.
Yes.
So.
Now, there's not too much time left, but I'm going to just throw a question to you in your remaining minute with us tonight, Buck. What do you think the Supreme Court's going to do in the latter part of June? I mean, many people are timid about expressing an opinion. This is a chance for you to
Yes.
say something.
Well, I'll take you back to something you were alluding to earlier, that we think that judges are about law, but unfortunately, judges are very often about politics. And I was predicting a 5-4 decision with Kennedy, Anthony Kennedy being the deciding vote. The vibes that I'm getting were such skepticism that I am now predicting, and of course I may rue this prediction.
Well,
a few months
you're on
from now.
public record
Yes.
now, Buck.
But I'm going to predict that the public requirement of buying insurance would probably be struck down by a close vote.
Yes.
So, but we can only wait to see. Maybe the Supremes might not even know as the decision's being written.
Well, we'll have to have you back when the Supreme Court renders its decision. Certainly,
happy to.
we have a lot of interesting times in front of us.
Indeed.
And thank you for all your wisdom that you've shared with us tonight. So thanks a lot for being with us,
Thank
Buck.
you for having me.
Thank you. Thanks.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.